time to say a very good afternoon to my guest, the Honourable Dr. Jocelynne Scutt, AO. Good afternoon, Jocelynne. How are you?
I'm well, Ian. How are you?
Yes, I'm good, thanks, and really nice to hear your voice.
Good. Same, likewise.
So we've got quite a lot to talk about today, haven't we, on behalf of 1950s women, and obviously, and it affects a lot of people, doesn't it? Not just 1950s women, some of these issues as well. But I wanted to ask you first about the judicial review regarding the winter fuel allowance.
Well, a body quite separate from CEDAW in law, of course, has instituted a judicial review of the fuel allowance. I mean, as you know, there's been a lot of discussion about this and the impact on people generally, but also on the 50s women, because although they're not the only ones impacted, there's been a lot of concern on their part that it will make their situation, bad as it is, even worse because of the fact that they've suffered from not receiving their pension at the date that it was originally indicated to them that they would, that is when they turned 60. And all of them paid into the National Insurance Scheme monies on the understanding that they would gain their pension at 60. And of course, nobody's saying that the rise to equalise the pension ages was inherently wrong, although one can find substantive arguments to say that it was, because women born in the 1950s, for example, and even today, we recognise that there's a huge disparity between women's incomes, the pay gap, and the pension gap itself. And the idea that we'll make everything equal means that everybody's going to be equally well off is simply false. And it's particularly false when you come to women. And this is the irony, really, that all over the world it's recognised that women's wages are not commensurate with men's wages, not because there's anything wrong with the work that women are doing, but because the traditional work of women has never been given the proper valuing that it ought to have had, whereas the traditional work that men do is, for some reason, given a far greater value. So therefore, coming back to the fuel allowance, there is this concern, particularly on the part of women, that it will impact against them more than they really are able to stand in accordance with the incomes they have.
Yes, so that's quite a consideration, isn't it? Quite a very serious issue.
There have been suggestions that the government might reconsider it, even in the current budget, or as time goes on and the impact is seen, and one might hope that that is what they will do. But whether this judicial review will have a successful outcome or not, of course, we need to wait and see on that as well.
Yes, so I presume we'll get a clearer, the budget's tomorrow, isn't it? I wonder what that will turn up.
Well, that's right. I mean, there's been so much publicity about the fuel allowance that in a way one could say, and often there is, a suggestion that if a government does what's called a U-turn, there's something wrong with what they're doing. But of course, if they, after reviewing what was proposed, come to a conclusion that perhaps what was proposed was not the best approach to take, then there's certainly nothing wrong with a so-called U-turn, with reconsidering and saying, well, we've changed our mind. There's nothing wrong with the government changing their mind if they come to a conclusion that a proposal was not the best way to go. So I don't think this U-turn argument gets terribly far. But yes, we have to wait until the budget tomorrow to see the full impact of what's being proposed.
Now, I wanted to ask you about the ratification of CEDAW, the international law, and the General Recommendation 40.
Oh, yes. Well, now, General Recommendation 40 came through the CEDAW committee. That's the Convention on the Elimination of All Forms of Discrimination Against Women. And I actually went to Geneva when that was being discussed and put in a written submission. And on Friday last, the General Recommendation 40, which is the one on women's leadership and women's power and the importance of ensuring that women are at the table when anything is being discussed that impacts women, and of course everything impacts women if one has got any sense in looking at the world and economics and policy and so forth. And so now this general recommendation has come down, which of course applies to all nation states that have signed up to and ratified CEDAW, so it applies here in the United Kingdom, and the proposition is yes, women must be at the table. And of course, if we go back to this issue of the 50s women and the pension issue, in 1995, when the Pension Act was went through the Parliament, proposing this change, which was to come into effect later, when that went through, of course, the Parliament was simply in breach of CEDAW because CEDAW had been already signed and ratified. And what that means is there are a couple of things that means. Number one, that the government on ratification should have had a review of all legislation impacting on women to make sure that it didn't impact negatively, that is, in a discriminatory way. And it didn't do that. And the fact that it wasn't au fait with what its responsibilities and duties were by ratification is evident in that it went and passed the 1995 Act that clearly discriminates against women, and they did that despite their obligation under international law, under CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women. Now, one can simply hope that the new government will have more consideration of its international obligations than the last one did. I mean, with the last one, there were a couple of approaches taken in relation to domestication of CEDAW. That is, once you've ratified, there is a legal obligation to introduce the provisions of an international treaty into domestic law. Now, the last government, had the approach that they couldn't do that until Wales, Scotland and Northern Ireland came to the table and were on board with regard to domestication of CEDAW. Well, of course, then Scotland's already wanting to do something to implement CEDAW domestically. Wales has got something on the table, and even Northern Ireland's moving towards that. Well, the argument now of the United Kingdom government, well, the last one before the new one came in July, its argument was, well, we don't have to do anything about implementing, number one, and number two, a contradictory position, well, we implemented it anyway through the Human Rights Act of 1998 and the Equality Act of 2010. So I do hope the new government will be more on board with international law and its obligations under CEDAW in particular, and that it will see its way forward to implementing the CEDAW Convention so that it is incorporated into domestic law. That should be on the table because, in fact, the Chancellor, Rachel Reeves, is absolutely on the ball when it comes to equal pay, because she made a commitment before the election that if elected, she would make sure that equal pay of women and men was actually brought into effect. So she's clearly mindful of women's rights, and therefore we might hope that the government itself as a whole is similarly minded.
Right, I wanted to ask you now about the CEDAW Article 8 optional protocol.
Yes. Under CEDAW, there is an optional protocol to which the United Kingdom has signed up, which means that if litigants on an issue relating to women's rights and discrimination have gone through the domestic process and are not satisfied at the outcome, then they can go to the CEDAW committee, the Convention on the Elimination of All Forms of Discrimination Against Committee, and take the matter there. And this is what CEDAW in law has done with this issue of discrimination, direct discrimination on the grounds of age and direct discrimination on the grounds of sex or gender in relation to the 1950s women pension issue. And the matter is now before the committee, and they have to advise CEDAW in law as to whether they're taking the matter up, and that issue is to be determined. If they do take it up, then they will review all the material that CEDAW in law has sent in, which clarifies and affirms the discrimination that the women have suffered, together with the maladministration, of course, in the failure to notify. And then they'll go to the government and say, what is your response to this? So that the government has a right to respond. And one can simply hope that because it's a new government, this may have an impact, a positive impact, I mean.
Yes, so is it... because I think, was it news weighted from Geneva, but you've just been there recently, haven't you? So is there also an update from there?
Oh, well, I was in Geneva this time for the Beijing Plus 30. You see, the Beijing Platform that came out of the Beijing Conference in 1995 is now coming up to 30 years, 2025. So we had a conference in Geneva, 2 days of civil society, the non-government organisations, discussing issues such as institutional mechanisms. You know, the fact that under the Blair government there was a committee that comprised women representatives of non-government organisations, and those women were an official body established by government to have a voice to the ministers or the secretaries of state, where policies that they were seeking to implement would impact on women. So the women were able to discuss these, and they had a direct voice into government. Now, unfortunately, in 2010, when the Liberal Democrat Conservative coalition government was formed, that body was abolished. Now, again, under the Beijing Platform, that body should still be there, because one of the principles in the Beijing Platform was that every government who signed up to it should institute an institutional mechanism so that women's voice could be heard within government through this process of non-government organisations having a voice. And so at Geneva, we discussed that, and all the non-government organisations who were there from the Northern Hemisphere endorsed again this principle of institutional mechanisms. I was involved in a working party that drew that paper up, and so that will be pressed on the present government to reinstitute that body. I mean, it actually advantages government. That's why it's really important that they do comply with the principles of the Beijing Platform, because it helps government if they have women's voice, and that's what's recognised again, coming back to the General Recommendation 40 that the CEDAW Committee finalised last Friday. But yeah, and then there were 2 days in the United Nations itself where governments were affirming what they had done to implement the Beijing Platform. And the United Kingdom was there, fortunately, and made a very positive statement. So we can trust that the current government is mindful of its obligations under the Beijing Platform, and it's mindful of its obligations to women and women's rights.
Yeah, that's very important. It's good to hear that. Good to hear that they've, they're mindful of that, and that hopefully something will come of that. Can we move on to mediation, Jocelynne, the letter to the Secretary of State for Work and Pensions?
Yes. Back in earlier this year, I think it was, the CEDAW group, CEDAW in Law, instituted a judiciary review. Two members of CEDAW in Law were claimants in that, and the judiciary review was put forward by John Cooper, KC, a very highly respected member of the English and Wales Bar, and this was put forward on the basis that the government, that is the Secretary of State for Work and Pensions, should engage in mediation in relation to the 1950s women pension issue. And the response to that judiciary review was that they apparently couldn't understand why this proposition might be put forward. Now, John Cooper and the solicitor that were engaged by CEDAW in Law were both of the view that the government had an obligation to engage in mediation. The judiciary review was put on hold because it takes funding, you see, if you're going to proceed with a judiciary review. And at that stage, it was not possible to have a cap put on the potential funds for which CEDAW in Law or the claimant might be liable if the judiciary review were not successful. So that was simply put on hold. So it's still there pending the potential for it to be reinstated. But meanwhile, a letter has gone to the Secretary for Work and Pensions addressing the issues that were raised contesting CEDAW in Law's proposition that it was a proper party with which to negotiate. First of all, they said, well, there's no dispute. Well, of course, that's simply factually incorrect, if I can put it in those terms, because it's absolutely apparent there is a dispute, because in the letter from, or in the reply from the department, they actually acknowledged that the Ombudsman report, for example, was being addressed by the Parliament and the government. Well, that means that they were addressing the dispute that had arisen because of maladministration that was found by the Ombudsman. Now, of course, we also know that there's discrimination in this. It's not just about maladministration. But anyway, there's clearly a dispute on hand. Secondly, the Undersecretary for Work and Pensions has met with another group and therefore conceded, really, that there's another group that does have standing to be the engage in discussion. So it seems rather odd that the department is therefore saying that CEDAW in Law has no standing for mediation, because the group with which the Undersecretary of Works and Pension has been discussing the matter acknowledges that it is acknowledged in writing that it represents 7% only of all the 1950s women. Whereas the letter that's gone to the Secretary of State for Work and Pensions makes adamantly clear the broad scope of CEDAW in Law's representation of 1950s women. And so that's one of the issues. So the issue is there a dispute? There clearly is. And the Undersecretary of State, by meeting with this other group, has clearly acknowledged there's a dispute, number one. Two, there's clear acknowledgement of a dispute because in the department's own letter, it acknowledges that the government and the Parliament is looking at the Ombudsman's report, which of course is not the only issue that's a part of the dispute. And three, on the issue about whether CEDAW in Law has standing, if another group has been granted standing by the Undersecretary, then it would be extraordinarily odd if CEDAW in law were not granted the same status and indeed the same courtesy of a meeting in order to negotiate a positive outcome. And in the end, what governments are there for is to engage in discussion or mediation where there are issues that are in dispute. And one would just simply hope that this new government, when it has a chance to really consider what the issues are, that it will come to the table and see that that's a positive way to address the dispute that has arisen around the 1950s women being targeted in terms of the change from the 60-year age for women to 65 to make it equal with men.
Yes, that's right. Thank you, Jocelynne, for that.
To take action to ensure that women do come up to a stage of equality with men, then you can introduce a special measure that may seem on its face to be discriminatory in favour of women, but because it's to redress and to rebalance so that women and men are ultimately equal, then it's possible to do that. There's nothing wrong with doing that. It's really like just having something in place to redress the balance and to ensure that women and men can be equal. Because you see, if you look at the change to the 65, from 60 to 65, well, women weren't going to be equal in terms of income and pension rights immediately because of the pay gap and the pensions gap that was in existence. And therefore, one could say, well, we can have a temporary special measure to bring that parity about. And that's what the proposal is in order to overcome this problem that's arisen because of the 1950s women and the way that the equalisation was brought about. And what the CEDAW in Law Group is proposing, that there should be, 1, payment of an initial lump sum for each identified victim of this 1950s scheduling of the introduction of the change, with as additional payments atop their state pension payments paid over a period, for example, of 5 years, for those victims whose national insurance contributions entitle them to compensation equal to their sums deferred. So it wouldn't be the total amount, but it would be a lump sum to everybody who'd been impacted in this way, and then over a 5-year period, a top-up to bring about this redress.